Oh, okay.
Okay, I just want everybody to get to know everyone else.
No, I'm here. I'm here. Morning.
Good morning. How are you?
I'm just doing introductions, so everybody gets to know one another. We have Leighton Beard on the other line that's joined us. I think that's an early attendee.
Good morning, Leighton.
And then we'll
good morning, everybody. Good to be with you guys. Thanks for the invite. Looking forward to interesting conversation.
great to have you,
Welcome.
Mr.
Thank you.
Beard. And we're waiting for just one more person from the other panel. So we still have a few minutes before we get going.
Good morning, this is Christian.
Good morning, Christian.
Morning, Christian.
Nice to be here. So I'll mute myself, but I'm looking forward to the meeting.
Thank you for joining. I'll start us at 10 on the dot. We have Marina is joining, so that's not a problem. We still have some speakers before her. So we'll just wait until we see the number of our members pop up. Good morning, Marina.
Morning, David.
I'm just testing out your mic. Good morning. Good to have you on board.
I am here. Just say good morning to everybody.
Great stuff.
Morning, Marina. How are you?
Very good, thank you. And you, Queen?
I'm well, thank you.
It is 11 o'clock. I'm aware of the time, just that we have a lineup in the lobby. We just want to clear them into the discussion first. So it will probably take a minute or two and then I'll get going. Good morning. We are going to start now. We're on 30 plus, I see here, and I've been given the go ahead from my comms manager to go ahead. I want to start out with saying good morning to all that are attending. A special good morning to all our government attendees, our chair and our board members of the DMA, and a special good morning to our members. Without you, we wouldn't be going on this journey. So just some house rules before we get going. Can I ask that everyone mutes their mic if you're not speaking? Put your phone on silent so there's no interruptions. And yeah, that's about it for the house rules. You can put your hand up if there's a question. We can do some questions after each speaker. Let's wait for them to finish their presentations and then we'll take on the questions. I am sharing the lineup. I'm not sure. Can you see it? The program is the. Can you see the program being shared at the moment? Fully, is the program being shared on my end?
Yes, thank you, David. We can see it.
Okay, great. Yes. Thanks. So I'm going to kick off now. So the reason behind the roundtable, as we call it, it was done as a progression to our journey on getting the DMA's new code developed. And this is part of the journey that we're undertaking. So just for some perspective to our members, the code that we are developing, the first round of the code to develop the draft was done with a company, the specialist Novcon, under the leadership of Elizabeth de Stadler and her team. So we sat with our intimate POPIA group with experts in developing the framework. It then went on to the board. That framework is now a draft. its third step is to be put out to associations like yourselves as well as members for their review. So this board is being, the code is being touched on by everyone in the industry that's in direct marketing, that has a say and a voice within the industry. And it is going far and wide for it to become, a code that is written by us for ourselves. And this code will eventually be presented to the regulator under the auspices of Advocate Pansy Tlakula and her team to review, and with the hope of it going through to being gazetted and being accepted as an industry code. But before we get there, we are interacting with the code. And through the journey of the code, there were very many questions that came our way. And I think there was, when we sat with the board, as well as some of the professionals that did interact with our code, the questions were showing a lot of signs of misunderstanding or not understanding the difference between what an OMBUT is or what an industry code is, and how far does that stretch, and where does it bring us? How close does it bring us to the regulator? And what does that achieve in terms of benefits for our industry itself? So the by no mistake is this panel setup. They are the key individuals that have and hold, we believe, the best knowledge in the industry, and can then depart that and demystify some of the steps for us. While I understand there are questions on the code is a working document. We would prefer that you write down your questions, and then that would be reviewed by our panelists. Either if it's seen to be of great consequence or material, form part of the code, or to form part of the guidelines that assist the code. So we're really looking forward to your inputs. Please put them down and email it to us. We will give you all the email details after the chat. And I think TD, our head of comms, has been already emailing everyone with the correct email addresses for which they can send back their inputs. So without further ado, let's get on with the introductions to our speakers. Professor Cedric Snail is our speaker that'll come up first. And then we'll go on. We're actually going to we may jump it around to Miss Marina Shaw, and then go on to Mrs. Queen Vulani Munyai, who will then speak from the Ombuds office. And we'll close with Mr. Oberholzer Stefan from Weven Online. So just to give you an introduction to Professor Snail. He's a professor, he's an advocate, and I know he's just on the brink of being doctor with all the work that he puts in cyberspace, cybercrime. He's going to give us a look at what POPIA and the code of conduct, what has contributed to our sector. So I'm just going to put this, stop sharing this document so that we can get a view of one another as we go on to the next, as we go introduce the speaker. Advocate Snail, if you could pop your face up and let us all see you. Is Advocate Snail still with us? Hope we don't have any load shedding in this area. Oh, there he is.
Now I'm here.
No, yeah, thank you. Well, we've been busy with our code. I think it's code season for many people these days, and you've come from quite the journey with pre-codes, writing the overarching documents that guide us all in this journey. And we just wanted to get a sense for our members out there, what is it, from POPIA's perspective, when the great minds sat together and looked at what the needs were for the country and the specific industry, what what were the key points of putting out the code and then, reaching out to stakeholders to say, you guys, you are masters of your destiny. Let's work together and design this path that the code leads us down. So can you give us a step back in terms of the code, why Popia, and then what is the benefit or what the interest of a specific association taking a walk down this line?
Okay. Thank you, Mr. Dickens. Thank you for inviting me to this roundtable. I think there's a lot of demystifying that needs to take place regarding codes of conduct, why codes of conduct, how codes of conduct, for what purpose codes of conduct. And I think those are some of the questions which I'll be able to answer in the next 5 to 10 minutes. So, as you correctly pointed out, the POPIA was created to regulate personal information. In other words, data protection legislation, which we've seen in South Africa and all over the world, GDPR, etc., etc. Now, because the POPIA has got the lawful conditions for processing, it became apparent, and I think not just to our drafters, but for the drafters of other legislations in other jurisdictions, it became apparent to them may be problems regarding some specific classes of persons or specific bodies or specific industries or vocations. In this case, we're talking about the direct marketing industries, that they would need a code of conduct. On the one hand, in order to properly comply with POPIA, in line with the inherent requirements that direct marketing comes with. We know direct marketing, electronic direct marketing is also regulated by Section 69. So it is really a regulated area. And it's not just the POPIA, we also have other pieces of legislations that we need to consider, such as the Consumer Protection Act as well. But with that having been said, the idea of creating a code of conduct for the direct marketing sector, I think is a way to try and assist the regulator and the greater nation at large to ensure that direct marketeers to a minimum standard in terms of protecting your personal information. And that when you are dealing with direct marketeers, you have some comfort to say that, look, on top of the regulator, there is also a sort of in-house mechanism within the industry. You can complain to the information, or you should be unhappy in terms of large-scale processing that is taking place in the organization. And this is done in order to also limit the amount of complaints that will be sent to the information regulator. We're not saying that the information regulator doesn't have capacity or the ability to deal with complaints, but what we are saying is, in addition to the role, by having an industry code for direct marketeers, this, as I said, on the one hand, will be a minimum standard for direct marketeers to adhere to data protection rules and to ensure personal information is used in a lawful manner and not abused. And on the other hand, this dispute resolution mechanism that I've mentioned, it does not replace the information regulator. However, it becomes a pre-dispute resolution mechanism so that not all complaints related to direct marketing end up with the information regulator. Now, the codes, as I used to say back in my regulator days, are not just for the taking. But I've seen now that there seems to be code season, as David correctly puts it, or a proliferation of codes that has come up. Now, obviously, it's a new phenomenon. Some of the jurisdictions that one can look at, such as the UK, they encourage the use of codes. Some jurisdictions in Germany as well, they also encourage the use of codes for some industries. So I think at this stage, the issue is about getting people to understand the importance of an industry code and why an industry code can add value to the direct marketing activities of direct marketeers. I think I'll leave it at that for now, and I'll give back over to David.
Thank you, Advocate Professor Snell. I remember I used to call you Advocate when you were at the regulator's office. Now it's Professor since you're at the university. But yeah, like you said, and if some of us just missed it, it is the industry code sets a minimum standard, as you said. But what we do is with our code, we add values, we add principles. So we raise the bar in just bringing the basic 8 principles. We say let's look beyond that. Let's add our professional layer so that we do better as an industry. And I think everybody's code kind of raises the bar in a sense, because we want our industry not only to thrive, but we want to be seen as a legitimate and a shining beacon in terms of compliance, especially in South Africa. I sit on the board of the GDMA, and rightly so, as you said, Prof. UK and Germany are definitely, they're submitting a lot of their codes, and they sit with their regulators and do a good job. I mean, we are on the ground, we know what it means to interact with data on a daily basis and the challenges that come with data leaks as well as breaches and the behavior of humans, because basically it's human behavior that we need to correct. And we're finding it's a huge educational drive that we're on all the time. But thank you for that. Can we take a question perhaps on what Prof was just discussing in terms of the benefits of a code? I'll give you a minute. If not, we've got many speakers lined up, so we're going to move on. I don't see any questions. So our next speaker So thanks for that, Prof. We're going to move on to the Consumer Bureau, Consumer Profile Bureau, and we're going to move on to Ms. Marina Short. So Ms. Marina Short, she is a current board member at the DMA, but she's the CEO of the Consumer Profile Bureau, and she's a CEO of the CBA, the Consumer CBA, and that is the Consumer Profile Association, Consumer Bureau Association. Sorry, there's a lot of acronyms being thrown around today. So we're going to say a good morning to Ms. Marina, and Marina's going to actually speak to us about, the reasons why they applied for a code. I think CBA, together with DMASA, they were the first to get their codes through the regulator, the Information Regulator's Office. And yeah, they took the journey based on a couple of pertinent issues that were in their sector. And we know with the consumer bureaus, it's extremely complex from a financial point of view. We're dealing with special data, we're dealing with masses of data, and we're dealing with profiling the South African on the street, their credit rate, credit worthiness, and how they behave out there in the market. So that was there's a lot of intensity and work with data. I'm going to leave it to Arenas to explain, what were the challenges? What were the challenges in the area of the bureaus that made the CBA as an association go and submit a code? And can you tell us the pluses and some of the challenges so that we can understand what that journey is like and what it currently is at the moment since it's been gazetted? Thank you.
Thank you, David. I think we can say, can the real Slim Shady please stand up? So I can say yes to a lot of the titles, but I'm an EXCO member on the Credit Bureau Association. We've actually got the real executive, Alison, is online as well, if there's any questions for her. But thank you very much. I'm going to actually just do a quick presentation. I just want to make sure, just want to see if I'm actually just stop sharing. I just want to make sure I get the right one here no, that's the wrong one. Sorry, I'm just trying to get the live one here. It seems to have too many open on my machine right now. Let me just get the right presentation going. Yeah, it's giving me a whole lot of different ones. Sorry, guys, I've just had a bit of a technical challenge here. Let me just get my bearings. Let me share. Are you guys seeing anything?
From what I see, I can relate the good, the bad, and the ugly of data.
Okay, I need to stop sharing that, and my machine doesn't want to stop sharing. Can one of you just stop the sharing for me? It doesn't want to allow me to stop sharing. Okay, looks like that has gone back. Okay, yeah. Cool. Let me try again. Otherwise, I'm just going to talk you through it. It seems like I've got a challenge here on what I want to share. So give me a second. It's definitely okay.
Try that again.
Okay, I think I'm just going to talk you guys through it. Let me just see. Yeah, there we are. Finally got it. Okay, apologies for that. Just start from the beginning. Can you guys see my presentation?
Oh, CBA code of conduct.
I just want to make sure that you can see. Okay.
Hands up. Yeah.
Awesome. Great. So I just want to take you guys through the journey that we had as bureaus, and it was quite a challenging journey for us. But being the first, I think that was part of the challenge initially. So if we look at, sorry, I've got a total screen failure. Okay, so what is a code of conduct? I wanted to have a look at just going back to the drawing board. So a code of conduct takes the POPIA principles. You apply this to the information, the activity or industry that a code is applicable to, and then the code must take general and translate it to specific, translate the principles into guidelines. So how is a code of conduct made? So there's one or two choices. The information regulator can decide to draft the code on its own, or it can be submitted by bodies who are sufficiently representative of the industry the code will regulate. So why would we want to do a code of conduct? Number one, it optimizes how personal information is used. It will increase the level of protection of privacy and the level of compliance for the industry. It sets out the rules on how to deal with the gray areas. It ensures uniform and sector-appropriate implementation of POPIA. It aligns the regulator and the industry's approach to information governance in the industry. The codes of conduct can also give the regulator comfort that a particular industry is committed to becoming compliant. And there I must recommend and compliment David and the team on how well they are actually aligned to the information regulator, and their communications is very good with them. Then also it can be a marketing tool. It demonstrates that you take data protection rights seriously. It is a mechanism to deal with complaints, and then you don't need to apply for prior authorization. It was quite a decision and a challenge for the bureaus. At one point, we were seriously considering whether we should be applying for prior authorization, but with the guidance from the legal experts, we hang on, and we eventually got our code approved. So the guiding principles to a code, it's important to know that the code is comprised of principles, not rules. The Act incorporates standard of reasonableness. It allows for flexibility to determine if data protection principles have been observed. The code is also a clarification of Protection of Personal Information Act. It must clarify POPIA and be written in an understandable language. The specific section, I got some information from Elizabeth and their team, and the code must harmonize existing data protection principles in the sector. The existing compliant guidelines need to be incorporated into the code. It's no need to replace it. A lot of times, the industries are already applying the basic principles. It's just how you align them then into the code. And then the standards set by the code must be achievable. That's very important. If the code is too difficult to apply to, then it will increase non-compliance instead of trying to decrease non-compliance. You have to take into account the cost and the impact of compliance into the account, and then the industry associations should consider providing tools and support to members to be compliant. We actually had a lunch with the reseller credit bureaus on Friday, and Alison was actually guiding them. As the industry, we are the main bureaus leading, but we are taking the rest of the industry with and making sure that we allow and provide them with the tools and the support for them to become compliant. I think very important, one of the steps that we had to take is to educate the information regulator on credit bureaus. This is a slide that was part of the presentation that was actually done to the information regulator. And something that we found is that they don't always understand the exact industry that the specific code is going to be applicable for. So it's very important to make sure that you properly position what are your actual functions and how and when do you actually touch this data. So we did have to go on a drive for that. And then a little bit of the journey. We were ready quite a while before April 21 as the bureaus, but we held back. The information regulator asked us not to submit at that point because they wanted to issue the guidelines. So once the guidelines was issued or the guiding principles, then we could actually realign our code to that. And we did get some external experts to help us during that process. And then we actually submitted that the 14th of August 21. So what's the purpose of our code? The purpose of our code was to promote appropriate practices by the members of the CBA governing the processing of personal information, encourage the establishment of appropriate agreements between members of the CBA and third parties, and the procedures for the members to be guided in their interpretation of principality of POPIA. The code governs all the processing of personal information, including consumer credit information. It just talks about the agreements again. And then in October 21, so this is a process, there's a few of them that I'm sharing, where it was actually notices were sent out by the information regulator. It was gazetted. We got the feedback from the industry. We got it back into our environment. We worked on it again, resubmitted that. Was quite a process going through. And then on the 23rd of September 2022, we finally had success. It was quite an achievement for us. We were actually the first code that got approved. And that was the notice that we got from the information regulator. I think it's important that this was then came into force on 28th day after the date of the notification in the Gazette. And it was actually submitted on the 25th of May, the 30th it was gazetted, and then was actually became in November, it was actually applicable. I think in conclusion, it was a long journey. The guidelines on the specific requirements for the code had to be established. The realignment to the guidelines was necessary from our side. The information regulator had to also establish the department and the processes during that time. Our code was published 13 October and became effective on the 4th of November. Very important, the CBA currently represents more than 50% plus one of the industry. We had to go back, and although there's different types of bureaus, the full bureaus, niche bureaus, and reseller bureaus, they were very adamant that we had to represent 50% plus, and we had to prove that. It was one of the reasons why it was resubmitted. And it was the first code to be approved. Key factors to consider: ensure the adherence to the guidelines that is issued. You make sure you've got enough industry representation. You've got to prove the collaboration and keep close to the regulator. And then I think another one, I'm also involved with the ADRA, Debt Collection Industry Code, now with the Direct Marketing Association, also the ACFE. I think it's important to note that you might have a client that is subjected to, like a debt collector, to DMASA code, to a debt collectors code, and a credit bureau code. And I think it's important that we got to consider how these codes impact each other. That's it. And I know Alison is also online. If there is any questions, I'm sure she'll help me.
Wow, thank you. And Alison, well done as the CEO of CBA. That journey was not easy, I can tell you. I see
Thank you,
from
David.
I'm experiencing it right now. But I think what I get from all the code developers is that, one, you know, you didn't just come into the industry yesterday. It was a journey. Before Popia existed, you know, there was a decision by the industries to raise the bar, regardless of whether we had, you know, any stick behind us. We took up the gauntlet ourselves, and we started formalizing on a principles and a values base our own codes, and we evolved with it into Popia, which kind of it makes for a quality association. So yeah, well done, Marina, and well, to Alison, who's the CEO. Were there any questions? No. Okay. Thank you. That was a great presentation. It really did set the tone for exactly what it means to be an industry code holder. And really, it is, I love that word, harmonize. It's a harmonization of the code and your principles and values-based code of the industry, and to stay close to the regulator so that you sit at the table. I think regulators have become, and I must say, I'm feeling it from IR, the Info Regulators Office. There's no more that top-down approach. Let's harmonize and let's learn together, because our individual areas are so complex. As best we write this journey together. So thank you, Marina, for that. I'm going to go on swiftly to the next speaker.
Sorry, David.
And
there is a hand up.
Oh, is there a hand? I see a hand. There we go.
Sorry, David, it's Alison.
Oh, Alison, go for it. Thank you.
Okay, David, I just want to say well done on your draft of your code that you've actually sent. I think you've managed to overcome some of the initial hurdles that we faced, which was really making it very applicable to your industry. Our first draft wasn't as applicable, and we redrafted in total once at least. Yes, we had some other issues where we had a lack of understanding on both parts of where we should be going and about our industry. But I do want to just compliment you on how easy your code is to read, and also how detailed it is in terms of your specific industry. So just well done.
Thank you. I think very like Marina said, and as your bureau has set out, it is, you need to consult. We were fortunate you guys have pioneered a way for us, and we've taken that mantle up ourselves to make for a more robust code. And obviously working with Novacon, who's already taken the journey a couple of times, we seem to be getting it right much faster, and fingers crossed we get over the line in the new year and we have an industry code that's accepted, no doubt. So I'm going to move on to our next speaker, who is Miss Queen. She is the CEO of the CGS, Consumer Goods Ombuds. So Consumer Goods Service Ombuds, CGSO, because there's another CGS, an association, and not to be mistaken with the ombuds. Now, why did I bring an ombud on? There's a nuance. There's a step between an industry code holder and an actual ombud, and there's a lot of also misunderstanding as to what an ombud office is. And I know a lot of people feel it's a scary office where there is some legal person sitting there, but I can assure you, when you take the journey into looking at the code of the ombud and you look at the vision, the mission, it demystifies a lot. So I'm going to hand over to Queen just to explain exactly from an ombud point of view your journey and what do you do for the industry as an ombud, because we play in the same consumer space. Thank you.
Thank you so much. Thank you, David. And I think you're not the only one that struggles between the Consumer Goods and Services Ombud and the Consumer Goods Council of South Africa. But I think my presentation will also help to differentiate the two, because I think what I'm going to do, I will give a bit of a background of how our code came about and the mandate of the Ombud Office and the benefits that we have seen. And I think a lot of the things that I'll touch on today will be based on the learnings or our observations since inception. By the way, we will be turning 10 years next year since inception, 2013. So in terms of the Consumer Protection Act, the CPA allows the industry or the minister to promulgate a code which is proposed by the industry. So what happened in our case is that under the Consumer Goods Council of South Africa, who is the industry association, like yourself as DMA, it's an association. So it's the voice of the industry who speaks on behalf of the industry. So the industry then, being led by the Consumer Goods Council, drafted a code, and it was also a journey. I think, like the others, I think it's quite comforting to know that it's always a journey. But I think for Marina's sake, the journey was quite short as opposed to our side. It happened, the process started before 2013, before my time. I, at the time, used to be with the Consumer Goods Council of South Africa. So the industry came together, which we called the working group. And I think it was quite interesting to know that the DMA was also part of that working group back then when the code was being drafted. So it was represented by industry players, being the retailers, the manufacturers, wholesalers, independent organization that were representing the consumer voice. They came together and drafted. It was submitted to the regulator, being the National Consumer Commission. And there was back and forth. After it being gazetted, there were comments that came from the public, and then there were corrections that happened, resubmitted. Finally, the commission submitted to the DTI. And the DTI at the time still gazetted the code for more comments. And finally, the code was only promulgated in April 2015. So you can see that from our journey, we've started operating in 2013. And I think the good thing from our side is that we were able to experience operating under the code, which was still not promulgated, which was voluntary at the time. And later, 2 years later, the code then got promulgated. And what I wanted to share quickly, maybe, is to show you that currently under the Consumer Protection Act, we have 2 codes that have been promulgated. And I know that you operate under the POPIA side where the information regulator becomes the one that promulgates the code. On our side, we have two codes, being the Motor Industry Ombud and the Consumer Goods and Services Ombud. So our role is to raise the standard of good conduct in the industry. So I think that is very important to note as we are going to talk about the code itself, the purpose of the code, because in the 2 years that we started operating, yes, we were still operating under this mandate. However, the challenge was that it was not compulsory. It was mandatory to those that were, if I would say, the good citizens who were willing to participate. But after 2 years, when the code was promulgated, it became mandatory for all the players in the industry to belong or subscribe to the code and also belong to the Ombud and also contribute to the day-to-day running of the budget to run the Ombud scheme. So we also generate it helps to generate growth in the industry, because what we do, we increase the level of certainty in the participants, whom you would call the members. That is very important, or we've seen it being very vital on our side, because now the industry players are now playing by the same rules, so to say. Whereas if in a voluntary space, then only those that are willing are then subscribing to the code. But the other benefits that we have seen over and above the other aspects that we work on, which are, for instance, to educate consumers about their rights, if ever there's any participant who breaches the code. I just want to show you this picture here so that you can see the effect of what we have seen, for instance, from 2013. In the year one, when we started to operate, we had 24 participants whom we call the founder participants. They signed up when the code was still voluntary. In the second year, we continued. It was quite a difficult journey during that time. At some point, we almost closed down, because we are an Ombud who is funded by industry. So with the 24 participants who signed up voluntarily, it was a bit difficult to break the ground for other participants who were still outside of the net. But in the second year, the code in 2015 became law that everybody who is operating in the industry has to subscribe. And you can see the growth there. We had 174 participants in year 2 after the code was promulgated. And from that year, we have seen an increase of an average of about 51% per annum. We're currently sitting at 1,400 participants at group level who have signed up to the code. And you'll see that the most participants have signed up after the code has become law, or it became mandatory to belong to the industry or to subscribe to the industry code. So I think what we have seen as attributes that I would say it's for an effective code is that we have seen that independence becomes very important, and I think it contributed in us getting a buy-in from the industry and the rest of the other participants who were waiting by the fence, waiting to sign up when it was law. So it is important that once the code is promulgated, while the industry association played a vital role to get it off the ground, there was a time when they had to create a separate entity, which is the Ombud scheme. So the Ombud scheme is an independent, the Ombudsman rather is an independent body who is now not for consumer nor the supplier, which is contrary to the association. Association is for the for the industry, while the Ombudsman stands between the industry and the consumers to deal with complaints in in a very impartial way and try and facilitate or mediate those complaints to try and reach an amicable agreement between the two parties. So while it's important to be independent, we also had to be seen to be independent, not only being independent at heart, if I may say, but we needed to cut that umbilical cord. And that's what the council has done after the code was promulgated. We then moved out and became an independent body and have our own register, a separate account or separate company, which is also a non-profit organization funded by industry. So it was much more easy to enforce that code after the promulgation of the code. And also accountability also became very key because our code was very clear to kind of point out what the code is about and how we are supposed to operate. The biggest thing is that in a code which is mandatory, it's an industry-initiated independent scheme which has the statutory backing. So the independent scheme is impartial and it belongs to the industry, which is very important for self-regulation, because if that does not exist, it means that the government or the industry gets now regulated by government. So it's very important to have a self-regulatory space, because then the industry has control. The industry is able to self-regulate, and they can also in the code include the provisions that talks to a governance structure, which is the board. And in our case, the board is constituted of the industry players, independent bodies, which is very important because it's like the industry itself is taking accountability to deal with the complaints that are or the problems that are created by industry. The industry is taking accountability to deal with those complaints, which is a very safe space because you can be able to have control. The board is able to provide strategic direction and not involved in dealing with complaints. They approve their own budget. They also approve the funding model. They appoint the ombudsman. The only difference is that although they have appointed the ombudsman and the CEO, the industry is not involved in dealing with the complaints. What happens in the complaints handling space is that when there are complaints that arise, the industry is given the first option to deal with complaints. Where the complaints handling or that the resolution of the complaint is not achieved at that level, that is when the ombudsman now steps in to mediate the process. So I think even from the direct marketers space, it is very important to get this code to be accepted by the whole industry, because what you want to do is to get the whole buy-in of the industry at large, so that it does not only apply to certain people, but it applies to the entire, and the whole industry is operating by the same rules. So you have the independent ombud, you have the adjudicator, and the ombudsman or the adjudication office then works it serves as an escalation process where complaints cannot be handled by the direct marketer themselves. If they fail to resolve those complaints, then they have an independent body that can then take over, and it works the same way in our area, because then we become that escalation process, escalation body that can deal, even if there are very difficult complaints, we are able to step in and assist. So the benefits include compliance with the CPA on our side. We also minimize the risk of formal investigation in the industry, because we know that if we don't go through the alternative dispute resolution body, we then go to the regulator, and that is much more formalized space, because the regulator can investigate and even go to if it doesn't get resolved at that space, then escalate it to the National Consumer Tribunal, where the industry players can also be given fines for contravening the Consumer Protection Act.
Can I just come in at this point?
Okay.
Thank you, Cree. That was absolutely detailed. I just want, just for the audience, what I hear is there's two parts. One, the Ombud is more of a statutory body, and it is neutral, so that it listens to two parties, both business and the consumer that's complaining about the good. And your office is, part of their task or mission is to have a fast, effective, affordable, and a mediatory position. So you don't want the issue to escalate, to become litigious, or it doesn't have to go into a legal issue. Yeah. So you want absolutely. So you want, you want industry to work smoothly, quickly, to fix any issues with the consumer, and you want the consumer who's aggrieved to be treated fairly. Obviously, your powers do extend. You can denote a fine or behavioral change, and they must adhere to that. If not, it would escalate. But yeah, that is the difference. Our difference in terms of where we headed is we are going for an industry code, and we still remains, a business remains our stakeholder. So like we were saying, that harmonization, the DMA, CBA, as well as the other code holders, they would sit at the table with the regulator to work on our path and ahead for our each independent areas of business, be it direct marketing or financial sector. So that gives us a seat at the table to kind of handle the destiny of our markets and play a role in it. But very, very much like what most of our codes want is fast, efficient, affordable solutions. And I think in today, since we are pioneering the way, I mean, on behalf of industry, we sit together with the likes of Marina and the likes of DMASA, because we've got to come together as industry leaders to say, how do we harmonize forward and act in the interest of both consumer and business? Because South Africa, basically, a lot of our decisions need to be based on the economy, on employment, but also on the rule of law. Remember, we want to be seen as international players. We want to have our doors opened, and we want to be a beacon of great industry compliance. So thank you for that. I'm going to move on to our next speaker. He is, there's Nelia Musaba. Hi there. You want to go ahead? There's a question.
Yes, it's more of a comment, David. Thank you so much. My name is Nelia Musamba, and I'm here representing the Banking Association, DMASA. I'm here with two of my colleagues. So thank you for the invite to this roundtable, and it's been very insightful to hear the views of the other colleagues. And I'm looking at the time and noticing that we only have 5 minutes to go, but we as DMASA, David, are willing and open to invite you to sit with us as DMASA. We have very extensive comments that we have done previously to the other submissions, and then we also have comments to the first draft rather, that is due on Friday. So we have noticed that some of our comments have not been considered. So it would be good for us to sit down and perhaps, discuss, because obviously the banking industry is a very big industry, and we do have certain I mean, already we have our code of conduct that does cover direct marketing. So it would be good for us to have a sit down and then just discuss how best, we can do it. Unfortunately, we won't be able to do that now. I'm just cognizant of the time. So this is just an open invite, and I'll pop my email in the chat, and then we can take it forward offline.
We will most definitely, and this is the process that we're going on with all our associations. So you're most welcome. Thank you for your inputs. I quickly want to go through to Stefan. Stefan, do you want to start your discussion in terms of where we're headed?
Yes, definitely. Thank you very much, David. I appreciate that. Thank you, first of all, again, as always, it's an absolute honor and a privilege to be, associated with the DMA and to be a part of a panel of respected colleagues. Thank you so much. I do realize we've got very limited time. I promised you 6 minutes, so let me try and, expedite this as well and not keep everybody unnecessarily. I'm going to share my screen with you all briefly. I've prepared just a very short slide deck, which also happy to share and to circulate. What I'm going to be speaking to you about today is really focused on the offering of the DMA, the DPCP, which some of you may have heard of, the Data Protection Compliance Program. I think it's an appropriate time to I don't want to say reintroduce the discussion, but to just speak to that, and also I think do so in a way. When I was preparing for the session today, I thought, what would be the best, most appropriate way of describing the DPCP without going into all the boring, detail and the legalese around it. I think, fortunately, my sort of Netflix addiction came to my rescue, and I think you'll get the point. You'll see where I go with it, but it's ultimately really very straightforward. The DPCP, and it sort of starts with this journey over here, right? So I'm going to just explain to you, I think, the essence, and then we'll go into some of the functionality very briefly. And if you guys have questions, please feel free to ask, or if you'd like to schedule some time to discuss it in more detail offline, also very happy to do that. So I don't know if some of you have watched, this particular documentary on Netflix of NIM's Purger. Very, very inspiring. I mean, long story short, the climber who has successfully climbed 14 of the world's tallest mountains, made history by summiting K2 in winter. You're going to ask me, how is this relevant to the DPCP? I'll show you in a second. I was really gripped by this particular story, and I thought, this really summarizes what we have done here, in partnership and in collaboration with the DMA for quite some time. Ultimately, I think that this particular, climber or mountaineer's story really speaks of, the principle of, with great power comes great responsibility. His journey really sort of highlighted the role of particular individuals, these Sherpas who assist climbers actually reach these summits, right? And I think really, in a nutshell, that is what summarizes the DPCP. Through this data protection compliance program, the detail which I'll go through in a second, the DMA really becomes your Sherpa, right? On your compliance journey and through this, ongoing learning expedition that all businesses and all of us have to go through. I think that that really, in a nutshell, summarizes what our heart and our intention and what the DMA's intention with it was. And what better way to sort of describe it than, this topical discussion and this really inspirational story. So, I think in brief, if you could imagine this platform, some of you have seen perhaps some of the functionality, some demo of sorts historically. But what we set out to do really was to develop and to deploy a platform which provides firstly access to a body of knowledge, right, to all members, large, small, across various disciplines, of various different tools, not only templates, learning tools, yes, templates in some respect, but a body of artifacts that could be used and ultimately applied to your business's compliance journey, right? That's essentially what we've done. And also for that platform to operate digitally and with agility. We've got our team, an extensive team of sort of diverse sets of skills, not only within the legal and compliance space, but we've got a very good understanding of how businesses operate, and we wanted to relay that learning into a solution that DMA members have got access to, right? So a platform which provides access to a body of knowledge that has got the context of practice and how business works practically day to day. And also, our focus is not only digital. Yes, there's a focus on purpose and people, and we, deliver through a digital approach. I think ultimately it enables a compliance journey that is perhaps more cost effective, generally more effective, and also really allows you to dictate the pace in many ways, right? So that really, I think, summarizes what the DPCP is. Ultimately, it's powered by forward thinking. I must give a tremendous amount of credit to David and the team, for birthing the sort of concept and the idea. I think you will still see the power in it going forward, but it's really powered by forward thinking, legal tech, and learning and compliance solutions that are uniquely compiled in order to provide a bespoke solution that enables members, specifically within this context, to take this compliance journey, which is an ongoing journey. It's an all-the-time thing, and it's everybody's job, right? So I really do believe that the DPCP methodology is changing the game in learning and compliance. Ultimately, there's also a significant e-learning component attached to it as well. And that really has been, or is the product of a fairly long-standing partnership between ourselves and the DMA. And I think we are now going to start seeing the fruits thereof. So just briefly, and I'll shut off in a minute, ultimately what we decided to do, or what we set out to do rather, was to take DPCP users, members, on a journey which enables them to identify where there may be certain gaps, design and develop a framework which uniquely addresses their needs and requirements, enables effective implementation, ongoing testing and training, which is all part of taking learnings and feeding it back into your business cycle, and then ultimately getting to a place where you are able to maintain a framework that is sound and that is also sustainable, and also to place you in a position where you are able to respond to incidents and disasters really effectively. So, have a business continuity mindset as well as a compliance mindset. So, we effectively, or the DPCP and the DMA effectively becomes your Sherpa, and we don't leave you behind, right? We don't just tell you what to do, but we actually help you do it as well. Right, so that really just explains the flow. I will also share this with you. It's not a problem. And I think in closing, what it really allows us to do is to, reach our objectives from a compliance and a business continuity perspective, and to then be able to look back and be at peace, right? So when I take a look at, the journey that this climate took, and please, if you haven't watched it, I urge you to. Very, very awesome. It really, is, I think, the story that epitomizes what we do, from a DMA, DPCP perspective for members, in order to, help you reach the top of your respective compliance mountains. So yeah, thank you. I know you saved the best for last, David, but I am running out of time, and I'll stop there. All right, thank you.
Look, I must apologize for the time. We're over by 5 minutes. We actually took on 5 minutes to get everybody into the lobby. Yeah, that sums up our journey. I think the last part, why we put that in the DPCP, Data Protection Compliance Program, is that to say we are ready, whether we grow from our current 300 plus to 1,000 plus, we have an instrument, a register, and a compliance portal that will help with the journey, because this is going to be a lot to do with education, but not just taking you up there, but giving you the tools to have your compliance framework done in practical terms. So yeah, we've been forward thinking, and we've been planning for this day. But yeah, I do not wish to digress. Our code is key. Please put your inputs on the documents. And yes, we will be around the table. This becomes part of now the intensity of putting the code together. We won't miss out on anyone's questions or inputs. We definitely will take everything to heart. It is the industry for the industry and to keep us as an independent, running, healthy body. I see there's one more hand. We'll take that. Yeah, Mohale.
Thank you, David. I just need to confirm that this session is not being regarded as consultation on the code of conduct.
Not at all.
Thank you.
No, not at all. We have to have it in writing, and we will then answer those emails in writing, and that would be it. That would be the right way to do it. This was just demystifying, bringing everyone together, as well as letting the industry know our intention. Definitely, we want to have the one-on-ones, and we want to make sure they're substantive in how we deal with it. So I'm going to close now. I don't want to hold everyone. We said we'd end at 12, but I want to thank everyone, our speakers, and those that attended. Thank you for your time. Have a good week ahead, and we will keep everyone noted. We got emails, and we'll be chatting and discussing as we go along this journey. Thank you.
Thank you very much, David. Thank you, everybody.
Thank you, everybody. Bye-bye.